Well, nobody could hear. Okay, now we're recording. All right, everybody. Welcome to Tuscaloosa, Alabama, which is where y'all are now in class. That means your professor has gone on again, I think for the 12th time, the most horrible trip that exists to travel between the United States and Ukraine, which is 14 hours or so overland to Warsaw and then 18 hours flying. But I made it. We're here in Tuscaloosa, Alabama. And I would give you a little tour, virtual tour of the campus, but nobody is here. It's a holiday for us. It's spring break. And there is nobody here but me teaching class. Everybody else is at the the beach or something, or gone to the basketball game. I have to send y'all. We're having our national championship basketball tournament just about to start, and they rank the teams before the tournament, and Alabama is ranked the #1 basketball team in the United States. We'll see if they finish that way. I know y'all are all going to be pulling for your school, the University of Alabama Crimson Tide, to be national champions of the USA in basketball, but we'll see. And I guess we had a little holiday last week, and it got a little confusion and missed class, I guess, for Women's Day in Ukraine. So happy Women's Day for everybody who missed that. And so we might need a little review to remind everybody exactly what we were talking about. So anybody remember and pipe in and tell us, like, what were we talked about 2 cases last time. It was 2 whole weeks ago. Does anybody remember what 2 cases we talked about?
Hay and Brooks.
Yeah, Hay versus Brooks is
And
one of
Butter
them.
versus Salt.
And Daugherty versus Salt. So that's right. We'll pick back up a little bit with those because, and I remember we talked about, I gave you a little form about how we analyze cases in American law school, and see if y'all can have a little practice being American lawyers. With those 2 cases, and then we'll talk about a couple of other cases. But remember, there's a case that y'all didn't read, but I told you about. I'm sorry. That's part of the problem with this computer. Somebody trying to call me from West Virginia. I don't think so. I don't know anybody in West Virginia. We talked about, I told y'all about a case called Cook versus Oxley from 1790 in England. And I know y'all are going like, God, why are we talking about these cases from 1790 in England? But actually, we'll get to that today and talk about that a little bit, about why we're talking about these cases from way back then. But Cook versus Oxley, remember the guy, he had a bunch of tobacco to sell. And he said, you know, I'll sell you my tobacco if I hear back from you by 4 o'clock this afternoon. And so by 4 o'clock in the afternoon, the guy responds, says, yes, I want to buy the tobacco. And the guy selling it says, no, forget it. And the guy said, like, you said, if I told you by 4 o'clock in the afternoon that you would sell me the tobacco. He probably decided to buy it, and he already had somebody to sell it to. It ruined his deal. And he went to court over it, probably lost a lot of money. And the court said to the guy who accepted the terms he was offered, remember the term was, if I hear from you by 4 o'clock this afternoon, I'll sell you all this tobacco. And so the guy who wants to buy it by 4 o'clock says, yes, I'll take it. And then the guy won't sell it to him. And the guy who wanted to buy it goes to court, and the judge says, forget it, forget it, forget it. You don't have a case. And why? Anybody remember, what's the general concept we've been talking about in these first cases? The main concept. And Daugherty versus Salt. And Hay versus Brooks. And Cook versus Oxley. It sounds like being nice to somebody, you really like.
About consideration.
Consideration, which usually, it's a strange term in this context. Consideration usually means like, I'm mindful of your feelings. That's what when we talk about consideration, I'm very considerate. Like I thought about your feelings, and I was very respectful. I was very considerate. But in contract law, consideration, what is consideration? You got to get what they're talking about when they're talking about consideration, or you won't understand anything about these cases and what they're talking about. And then I'll tell you why you even need to understand the concept. What is consideration? What future president of Ukraine or Supreme Court justice can step forward and tell me what is consideration?
Well, consideration is like a promise. I mean, when a promise given by promisee in exchange for their promise, I guess.
Well, you're on the right track, and actually that's something that they argue about in these cases. Like, Cook versus Oxley is really about the question, can a promise be consideration? So in Cook versus Oxley, the court says, the guy made a promise and he didn't keep it. And normally we think that's wrong. He said, if you get back to me by 4 o'clock this afternoon, I'll sell you this tobacco. The guy gets back to him and he says, nah, I'm not going to sell it. Which we think he's a terrible person, right? He didn't tell the truth. He wasn't honest, but he has no legal consequence for it because of this concept of consideration, which means, but you're on the right track. It's like, so a contract involves promises between two people that are binding. We promise back and forth, and we both have to keep our promise. And consideration is this whole question of what makes the promise binding. If I say, Anastasia, I love you, I'm going to give you $1,000. Then Anastasia comes back and says, takes me to court for her $1,000. What's the court going to say? According to the concept of consideration.
There was no consideration.
There's no consideration because she didn't give me anything for the $1,000. It was like a gratuitous promise. So the law is weird. Usually think, we need to keep our promises. But according to the law, you can lie, apparently. You don't, a promise is not a binding contract unless somebody gave you something for that promise. And you're right that the cases get into like, well, can a promise be consideration for another promise? But in in Cook versus Oxley in 1790, the court says, no, the guy doesn't have to sell the tobacco. He promised he would, but you didn't give him anything for that promise. So therefore, he doesn't have to keep the promise. Does that sound right to you? Don't have to keep your promise because nobody gave you anything for the promise. What do you think? Well, it sounds terrible, doesn't it? You don't have to keep your promise. Sounds terrible, but that was the law in 1790. If nobody gave you anything for the promise, you don't have to keep your promise. It's just, you can make a promise, but you don't have to keep it because, nobody gave you anything for it. Nobody gave you any consideration. So that is the concept that all of these cases we've read so far are talking about this concept, and they're developing the idea of really, I asked you, what is consideration? It's not that easy of an answer. All of these cases are about what is consideration? What is something that is of value, or you either gave something of value or you suffered a detriment to yourself for the promise that somebody else gave you. And that's what all these cases are about. And they wallow around in the mud about trying to figure, is this consideration? Is this not consideration? And that's the first thing you should understand is, and especially in this common law system, is like there is not a real easy, cut and dried, clear answer that the cases sort of argue about and kind of determine. They bring these individual cases and they argue about it and they decide, yeah, this is consideration, that's not consideration. And so our understanding of what is consideration, that depends on, all these cases. And it's also, you should understand, it's a concept that develops over time. So this Cook versus Oxley, that was in 1790. And that's kind of the point. That wouldn't work in today's modern commercial world, would it? Where you're doing business between Ukraine and the United States, and you're making contractual promises back and forth. And then you can say, my contract that I made between Tuscaloosa, Alabama and Irpin, that's no good because at the time I made the promise here in Tuscaloosa, Alabama, you people in Irpin didn't give me anything for the promise at the exact same time. Therefore, I don't have to keep it. Obviously, that will not. Anyway, it's understanding the history of how contractual relations developed and according to these concepts. And I know you're thinking like, oh, Professor, why do I have to understand this stuff that happened in 1790 that nobody follows anymore? And I'll try to give you an example. And I know y'all are, wanting, more practical and modern information other than, what was the law in England in 1790. But let me give you a current example of why it's important. And the idea is that the law is based in these theories, and it's a developing theory. And if you want to change the law, you have to understand what the theory of the law is now to be able to change it and develop new things. How many have any of y'all ever heard of Ben and Jerry's? You know what that is? Maybe not in Ukraine. Everybody in the United States knows Ben and Jerry's is an ice cream company. Y'all eat ice cream? No. Well, it's winter time.
We love it.
I'm sorry.
We love it, but didn't know the company.
Yeah, so Ben and Jerry's is a famous ice cream company. And if you went in the mall, like you went in the Gulliver Mall there in Kyiv, you'd probably see a Ben and Jerry's shop selling ice cream. And they make up all these kind of crazy flavors of chocolate chips and raspberries and different things. But it's also known as a very socially conscious company. like they're concerned about social issues, not just concerned about the money that they make. And that has developed into a commercial concept in the United States, and maybe has spread to other countries, but it's something that's just developing in the United States. It's a kind of company called a benefits corporation. And, a corporation, people get together, a company, to make some product like Antonov, we make planes or whatever. And their main purpose is to make money. There's actually law in the United States, and corporations are owned by their shareholders, right? Y'all understand that? Like there's a company and people own shares in it, and they're the real owners of the company. There's a famous company in the United States, Ford Motor Company, which I've seen Ford cars in Ukraine. There are not that many of them, but they're around. It was the first mass producer of cars in the United States. And Henry Ford's a very famous, controversial person. I went to college with his grandson, and that was another story. But anyway, Henry Ford, y'all ever heard of Henry Ford? But y'all heard of Ford?
No, of the Ford creator.
Yeah. So anyway, Henry Ford was the founder of the Ford Motor Company back in the early 1900s. He was a very famous person, became obviously very rich, the first person to figure out how to mass produce cars, to have an assembly line that turn out, 500 cars a day and at a cheap price and sell them to people all over the United States, and made cars very popular in the United States, made lots of money. And he was a very wealthy, very well-known person. And he started the company, and he thought, it's my company, I can do whatever I want with it and do whatever I want. But actually, it was a corporation, so he had sold shares. He had shareholders, the people who put up the money to start the company. And they had a big argument. They said, no, Henry Ford, you think you're a big shot, but you can't just do whatever you want with this company, because we're the shareholders and you have a responsibility to us, and your responsibility is to make money for us. That's your job, not to do whatever, you want to. And they actually went to court, and Henry Ford lost. It was a U.S. court case, said, yeah, Henry Ford, he might be the founder of the company, he might be famous, he might be rich, but he can't do whatever he wants with the company. He has a duty to the shareholders, and his main duty is to make them money. And so that's what he has to do with that company. So that creates a concept where, and it's become exaggerated over time, where corporations in the United States, their only duty is to make money and make money now for the shareholders. That has a lot of problems commercially, economically, because sometimes what's best to make money for the shareholders today is not necessarily the best thing. Oh, sorry, everybody was calling me. Not necessarily the best thing long-term for the company, and certainly not maybe in the best interest of the community or of the country or of the world. For example, if you have a company and you produce a lot of toxic waste, it's good for the company if you just dump all that waste in the rivers. Like, we got rid of the waste, we just dumped it in the river. That didn't cost us any money, and so we made more money for our shareholders. So if you're just thinking about the shareholders, it's like, just dump all your waste in the river, because then it doesn't cost our company anything, and the shareholders make more money. Of course, that's just passing the cost to somebody else, and then the government or somebody has to come in and clean the waste out of the river, or else it doesn't get cleaned and people are drinking dirty water. Everybody else suffers a detriment. So anyway, there's a concept that's developed over the last 30, 40 years. And Ben and Jerry's ice cream was one of the original ones where they're trying to develop a concept where the company's only duty is not to make the most money possible right now for the shareholders, and to consider social values, the benefits of the community, the benefits of the workers, the health of the people, the health of the environment, and to make all those kind of treated as economic values for the company. And so there's actually been legislation passed in a lot of states of the United States. So when you create a company, you want to do business, you create a corporation, and that gives you a lot of benefits. I don't know what the law is in Ukraine, but in the United States, if I want to have a business, I don't have to create a company. I can just go out. If I'm making, ice cream like Ben and Jerry, I can make ice cream in my house, and I have to get a business license, but I can go out and sell it by myself. But I'm much better off if I create a corporation to do it, because one thing that I'm protected from liability. If the ice cream truck runs over somebody, they sue the company. They don't sue me personally, so you're insulated. And anyway, there are a lot of tax benefits and other things. So anyway, so if you're going to create a business, you usually create a corporation. So like Ben and Jerry's, and usually the corporation under the law, back to the case of Henry Ford, the duty of the corporation is to make as much money as possible for the shareholders of the corporation. But there's been a new kind of a legal entity created, established under law. It's called a benefits corporation, where the company can consider other values like social values and environmental values and health values, and consider other things than how much money is made for the shareholders. And that's called a benefits corporation. And Ben and Jerry's was one of the first companies. They make ice cream, but they said our mission is not just to make money for our shareholders, but to do good in the community. And they actually have it in their corporate charter to donate money to charities and things like that. And there was a case challenging that when another company, Ben and Jerry's made a lot of money, so another company, Unilever, actually came along and bought them. And then the question was, can the new company change the mission of Ben and Jerry's so that it's not for all this social consciousness? And I'm going to see here, try an experiment here, see if I can share okay. The host has disabled screen sharing. So I'm not the host of this meeting, I forgot. So I can't share my screen, but okay, we'll have to see about that. Anyway, but you're wondering, Professor, what has this got to do with what these cases are talking about, consideration? And I'll tell you, and how this idea that they were arguing about in England in the 1700s is relevant today. So there's this movement to try to create something called a benefits corporation that considers, the good of the people and the good of society, not just the, money that the company makes for the shareholders. And when another company tried to buy Ben and Jerry's ice cream, and there's a big question of like, can they change the charter, or is that binding? Is that a binding agreement that this company will donate all its money to charity? Like there's some benefits corporations that have set up what's called a green revolving fund, where all the profits that come into the company go to help the environment. would go to like protect the Dnipro River or something like that. And the question, it came up in court when another company tried to buy Ben and Jerry's and take over it, was can they change the charter? Ben and Jerry's had a corporate charter saying we're devoted to social causes and donating to charity. And when that was challenged in court, what do you think was the argument of the people who were trying to say that the Ben and Jerry's charter that called for the company to be socially conscious and to develop and to donate to charity, why did they say that was not a binding charter? Think about Hay versus Brooks, Daugherty versus Salt, and the concept that we've just been talking about. And I'm not talking about being nice to people. I'm not talking about being careful about their feelings, but I'm talking about the legal concept of what? One of you just a few minutes ago told me. What's the concept under all these cases?
Consideration.
Consideration. So when Ben and Jerry said, you can't change our corporate charter says we're devoted to social causes, we're devoted to protecting the environment, we take our profits for our company and devote it to the health of the people. And what do the people trying to take over the company say? That's not binding, because why? Because the company's promise in its charter to devote the company profits to good causes was, just like in Daugherty versus Salt, these cases, it was gratuitous promise. Nobody gave them anything for that promise, and therefore it's not an enforceable promise in court. So that another company can come in and anyway, that ended up not happening, but that was the argument. That was the battle in court about whether that promise was enforceable. Just like we talked about with Hay versus Brooks and this other case, Cook versus Oxley, is the promise enforceable? And so that just gives you a modern idea of how this concept of consideration is still at play in the modern world of commerce today. Everything is based on these kinds of concepts. Okay. Now, here's a question. So y'all promised me that, and y'all have had 2 weeks now, that you're going to take these cases we talked about, Hay versus Brooks and Daugherty versus Salt. And remember, I gave y'all a framework that American law students use for analyzing cases. We call it briefing the case. And I made y'all promise to try to brief those cases. Does anybody have a, and you know what I'm talking about, where we talk about, and I can't share my screen, but maybe Artem, if he's there listening, he's got a chart for this where first you say, what's the issue in the case? First question, what's the issue in this case? What's the procedural posture? What are the key facts? What's the legal rule? What's the holding? Did anybody try that exercise for Hay versus Brooks or for Daugherty versus Salt?
I tried with Daugherty versus Salt.
So what did you? Let's try to. So here's one person. The rest of your classmates said, that was a gratuitous promise. There was no consideration, and therefore we didn't do it. But one thing in school, the teacher doesn't need consideration. The teacher can say, you know, do this for an assignment, and you have to do it. So anyway, so for Daugherty versus Salt, just and it's a good exercise. Don't worry about being exactly right. But what did you write for? Let me see. Is it Tatiana Cherchenko? Is that right? Chernenko. Tatiana Chernenko. Okay. So what did you write for what's the issue of the case?
Was the promise illusory or not? Whereas there are sufficient grounds for the mandatory fulfillment of that promise.
Yeah, okay. And that is correct according to what the court says. Do you remember what I said about that?
Yes. They said that the aunt said that he loves a boy, but it wasn't a consideration.
Yeah, that's what the court said. But remember, in the case, the auntie wrote a note. She didn't just make a promise, she wrote a note. So Tatiana, what you said is correct in terms of what the court said the issue was. If you were the lawyer arguing with the judge, what would you say the issue was if you were trying to get a different result? You know, the judge says the issue is, was there consideration for this promise? And was the aunt's love, and specifically, was the aunt's love and affection for her nephew, was that consideration for the promise?
She said that she wanted to take care of him. Maybe that's will be a consideration.
Well, yeah, and especially because she says, you've always done good things for me. So you could say, well, the good things the nephew has done for the aunt, that's consideration. So there are a lot of ways you could argue there was consideration, but what else could you argue?
The note was signed.
Yeah, it's a note. It's a formal document. And think back to, let's go back to Hay versus Brooks. And I'll give y'all a little history lesson. I didn't expect y'all to understand, but I'll just tell y'all, Hay versus Brooks was a case in a sumpsit. And that's a weird English term that nobody uses anymore, but that's from the history. And a sumpsit, that was a contract case for an alleged contract that was not under seal. Do you know what I mean by under seal? How many of y'all watched the movie Dune? Do you know the movie Timothée Chalamet? They're on an alien planet. Maybe y'all haven't seen it in Ukraine. But anyway, in the olden days, under seal meant for a document to be official, it had to have a seal on it. So they melted some wax. And if you were a lord, a king or some very important person, you had a ring, big ring that had imprint on it that, you know, was your kind of signature. And for a document to be official, you'd melt some wax on it, and you'd stick your ring in there and make your sign there, and that was your seal. And so in the real olden, you know, antique times, that was what made a document official. And that's what made a promise binding. And that's what made an agreement enforceable, was just the formality, pure formality of boom, I put my seal on it, therefore it's binding. And
Improvement.
kind of a what?
Improvement.
Yes. Yeah. It shows I have this has given my authority. That's exactly right. And that would make a promise binding. None of this, do I have consideration? Did I give value? Did I give up something for the promise? It was pure formalities made an agreement enforceable. And then they got to this idea of a subset where you could have in Hay versus Brooks, that's one of the points. The document was not under seal. There was no seal on it. So then they had to go like, well, was there consideration for the promise? So, but the point being that we still observe certain formalities. If I write you a check, we talked about this before. Americans used to walk around with checkbooks, and if you owed somebody some money at the grocery store, you could write a check, say, I owe the APB grocery store or whatever, or what's the name of the store? Novus. I go to Novus and I buy a lot of chicken and steaks and potatoes, and I owe them 1,000 grivna when I leave. I could just write on my check to Novus, pay to the order of Novus, 1,000 grivna, full, give it to them. When they go to the bank, do they have to prove what was the consideration for my promise to pay them 1,000 grivna?
No.
No, it's just the pure formality of the document. It's enough. I signed it. It's like I put my seal on it. I said I owe them $1,000, and boom, they don't have to go prove, oh, it wasn't just for love and affection that he gave us 1,000 grivna. We gave him some potatoes. They don't have to say we gave him potatoes. We gave him some chicken. They don't have to prove any of that. And in this case, Dari versus Sol, the Ani has written a note. If somebody writes you a note, do you have to prove? You take the note to the bank. Remember we talked about have a wine import company, and somebody sends me a letter of credit, says, we owe you $10,000. And actually for that, I would have to do something. I'd have to provide some documents to prove that the wine was delivered. And so anyway, different contracts work different ways. But for a note, you don't necessarily have. So the point is that the judge said the issue was there consideration for the promise for the $3,000? The judge could have said the issue is that's not the issue because she wrote a note. And there's other facts that you could look at. And the reason I'm going through this is because, not so much that you have to understand this crazy old case, but you do need to, and this is what American law students do, like train your mind to analyze these cases so that you can win your case. So if the judge is about to decide, the judge is up there, he's banging his gavel and saying, I don't think there was any consideration for this promise. Then you could jump in and say, Judge, that's not the issue. Because the aunt wrote him a note. And the note's enforceable. Then you have to prove that, whether it was love and affection. Anyway, and there's other facts in there, because she said that she, the way the case played out, I guess the auntie died, and then after she died, the boy tried to go and collect on his note, and they said no consideration. But what if the day after she wrote the note, he had gone to the bank somewhere and said, give me $3,000 for this note? What would have happened? or if he'd, gone to his auntie the next day and said, here's the note you gave me, now give me $3,000 cash. Could the auntie say, I don't have to pay the note because I only gave it for love and affection? Not really. I mean, and the other point being, and in American law school, I'll tell y'all, they torture the law students because all these cases, they could be decided a lot of different ways. And there are a lot of different things you could argue. And everybody comes to law school thinking, oh, I'm going to find one rule. I'm going to find this little set of easy rules to follow. And then I can be a lawyer because I have that. I went to school and I learned these rules to follow. And that's not really the way it works. It's this kind of torture where you could have, argued a lot of different things in these cases, and somehow they come out the way they do, and who knows why. It's a kind of a mystery sometimes. And the other thing to understand is that the United States is like 50 different countries, 50 different states, and every state has its own law. And these cases could come out one way in one state and come out a different way in another state. And that creates what are called majority rules and minority rules. And anyway, it makes it all very complicated. But anyway, it's just another reason that to train our lawyers, we train them to go through and analyze these cases. So anyway, Tatiana, you told me what the issue was. What did you write down as the key facts of the case?
The plaintiff received from his aunt a promissory note for $3,000 payable at her death or before. The boy's guardian told that the aunt was visiting her nephew, and she said that Charlie was a good boy. She loved him, so she would like to take care of him, and gave him a $3,000 note for $3,000. Then she gave the note to the boy. A blank was produced, filled out, and signed. But after aunt's death, the boy received nothing.
Yeah. So, a lot of those facts that you just related actually don't support the court's opinion, because, for instance, it said to pay on her death or before. That's what I said. Well, what if the boy had gone to the aunt before she died and said, pay the note? Could she have said, no, I don't have to pay because I only gave that for you for love and affection, and that's not binding. That's not consideration to create a binding promise. The other thing to understand out of this is usually in a contract, if you go to court with a contract, and a note is a contract, it's a contract to pay $3,000. There's usually what's called the parole evidence rule. Parole is a French word, means word. And what it means is you go by the words in the contract. So in this case, the contract was a note to pay $3,000. But in this case, the court didn't just look at the contract, which is normally the rule in court. If you go and argue, as you need to understand, if you have a contract, with an American company to rebuild the bridge at Irpin, then, and you go to court arguing over it, in the United States, the court is going to look at the contract and what are the words in the contract. They won't consider only in certain limited circumstances, and that's part of what we'll study and learn in this case later on, but this introduces the concept is normally you don't look outside, the court won't look outside what's written in the contract. There are only certain circumstances of maybe fraud or something where you can make the court look at the evidence of how the contract was created and what people said at the time they created the contract and all that. Normally the court will just look at the contract and that's all. look at anything else. And in this case, the court did the opposite. The court ignored the contract, which was a note for $3,000. And there was really no evidence that on the face of the note that it wasn't valid. Do you remember what the defendant, the executor, and understand the executor? So the auntie has died. So the executor is the person who's administering her will. And remember what the executor argued? Did the executor argue, oh, we don't have to pay because that was only given for love and affection? Again, learning how to read these cases and what to look for. And, one thing in fact, that reminds me, I should add to my little chart I gave y'all for briefing the cases. I knew I'd left something out, and this I'm just reminding myself. Another thing you add to your chart is the position of the parties. So there's the issue. Was there consideration for the promise? And then the next thing should be, what are the positions of the parties? What did each side argue? What did the executor argue? Did he go to court and say, we don't have to pay because she just gave this for love and affection? And again, and I'll get somebody to send y'all a chart with all of these little factors. And I think every time you read one of these cases, if you try to answer the question, what's the issue in this case? What are the positions of the parties? Then when we're in class and I ask you, what did the other side argue? You won't be lost, because you will have already figured it out and you'll have analyzed the case. So in this case, the executor did not say, I'll be the nice professor today and give y'all the answer. The executor did not say, the promise is no good because it was just for love and affection and that's not enforceable. No, the executor said the signature on the note was forged. It wasn't really her signature. That was the defense. And the court did something also unusual. He didn't consider the defense. He actually considered the evidence outside of the contract, which is that the little boy's lawyer presented testimony about the circumstances of the writing of the note and said that the auntie had said she wanted to do something for the little boy out of love and affection. And then the judge said immediately, the little boy loses because love and affection is not consideration to create an enforceable promise. Probably a terrible case and a terrible decision. But like I said before, these old cases, the facts of the cases get forgotten, and all anybody remembers about this case 100 years later, or whatever, is that love and affection does not create an enforceable promise. You tell your girlfriend, I'm going to give you $1,000 because you're my girlfriend, and then she breaks up with you. She can't come back and say, give me $1,000. You promised you would. You say, well, you can't enforce that. That was when I loved you, and now you broke up with me. So, okay, but I want y'all, and the good thing for y'all is y'all really are not going to have new reading to do, because we haven't gotten to some of these cases. And you might feel like, oh, professor, you're killing us. But the cases I've already assigned for y'all to read, we're going to go through these the same way and try to analyze them. And I want y'all to, So y'all don't have any new reading to do, but what your assignment from your professor, which is an enforceable promise that does not need consideration because professors can assign students to do work and don't have to have consideration for it, is go through these cases and and read the cases again and go like, write out. And mind you, it's and not in a careless way, because in the common law system, it's the facts of the cases that create the law. And so instead of having a general principle that's written down in a statute book, there's a rule that came out of the case that it's limited by the facts of the case. So for example, this would be a different case with some different facts, and it might have a different outcome. And that's why students learn to analyze these cases the way we're talking about, because what you learn to do is there might be a case that say, this case says this was not good consideration, the little boy lost. But if one fact changes, maybe the little boy wins even under this crazy rule that the judge came up with in this case. So when you ask, what is the issue in the case, you need to be very precise and tailor it to the facts of the case. What is the issue? And then what are the positions of the party? What did each side argue? Each side comes to the court and said, this is why I should win and they should lose. And so you need to, in your little diagram of the case, write down, the plaintiff said he should win because this. And the defendant said, no, the plaintiff should not win because of this. And again, try to be very careful and precise on the way you word it. And then the procedural posture, which is what stage the litigation is. We'll talk about that more later in some other cases. But then think about what are the key facts? What are the facts that the court used to decide this case? And that helps you in the future. If somebody comes up and argues in court against you and says, under the rule of Daugherty versus Salt, you should lose. And then you can come back and argue and say, no, you're wrong because our case is a little bit different from Daugherty versus Salt. So it's not the same rule. And so I should win in spite of Daugherty versus Salt. So when you're talking about the key facts, there are two parts to that. One, what are the key facts that the court relied on? And like here in Daugherty versus Salt, there are two versions of it. So what did the court rely on? And then the second part of that is like, what are the key facts that maybe the court should have relied on that it didn't? So here, the key fact for the court was, the aunt gave it to, promised this money to her nephew out of affection. And the court said, that's not enforceable. Of course, you could say, well, actually the court got the key fact wrong. The key fact is that she wrote him a note. So think about that. And then the legal rule, what is the rule that the court relied on here? So what was the rule the court relied on in Daugherty versus Salt?
The consideration is required in any contract or any promise is illusory.
Yeah, that's right. And so here, love and affection is not consideration. So and so then the holding is applying that rule to the facts. So if the rule is there has to be consideration for a promise to make it enforceable, then here and see how in all of these cases we're learning a little bit more about what consideration means. So here we learn that, well, according to the law, as it's understood, love and affection is not consideration. And so, the holding is applying the rule to the facts. So if there has to be consideration for a promise to make it enforceable, the auntie's affection for her nephew was not consideration to make the promise to pay $3,000 enforceable. So, okay. We'll get on here to, and then, and every time we talk about these cases, and the next few cases are, again, they're all defining like what is consideration and what is not consideration. And think about what I talked about the benefits corporation. You know, what's, you know, what is consideration for the promise of the corporation in its charter to donate his money to charity or to help the environment, and is that enforceable? That's coming into the modern world. Okay, let's start on Springstead versus Nice, the next case, and then I might let y'all go a little later. What's the weather like in Kyiv today? Nobody's been outside yet.
It's sunny.
Yeah, I hope it's nice. So, you know, I was there from February 4 to March 10th or 11th, something like that. When I got there, it was so cold, I thought I would die. But we started to have some nice, pretty days. So y'all are about to get into the springtime where y'all are not going to want to study and read all these cases. So we better work on them hard now. Okay, let's start on this case, Springstead versus Nice. And again, understand that all these cases we're starting with, these are famous old cases. You might say, oh, Professor, they shouldn't be famous. They were terrible. But these are famous cases that, you know, all American law students know. And so that's why one of the reasons we're reading them. The other is it shows how the history of how these ideas, you know, were worked out, how the courts, you know, wrestled with the idea of what is consideration. Once they decided you have to have consideration to make a contract enforceable, then, okay, what is consideration? And so we're looking at all these famous old cases to see what we can learn from them. And then Springstead versus Nice, this is like, it's almost like something in a movie where the famous case, it's the famous case where the family opened the box. And when they opened the box, this problem sprung out of the box. Like y'all know the myth, the story of Pandora's box. You know, be careful if you open the box, you know, don't tell them what's in the box. This is almost like a legend. They opened the box, found a document, and created this famous case that, you know, the poor family there, they were just worried about, you know, what they were going to get from their father when he died. They didn't know when they opened that box that it was going to be a famous case that law students in the United States and now Ukraine would study for 100 years. They were just worried about what was in their father's will. So somebody tell me what are the basic facts? What's the scenario in this case, Springstead versus Nice? I already told you it's about the case where the family's sitting around and they open a box. And what happens when they open the box? Well, they open the box and there's a document inside, right?
Inside was the deed to the Atlantic Avenue property, and it was given to the Sophia.
Yeah, so y'all understand what a deed to property is? It means, you know, you own the property. It's the document that says who owns the property. And Tatiana, you're doing great, but some of y'all, some of your classmates need to help you out. Next time, we need to have more people talking and able to answer some of these questions. So anyway, the family's sitting around, their father has died, right? And so they open a box. They want to know, what did our father leave us? And they pull out this document and they're surprised because there's a deed to this property. They thought that their father owned the property and that maybe in his will, he would give the property to, you know, split it up between all the children. But they find out that no, that the father owned the property in trust for 2 of the children, not all of the children. So remember, the lawyer picks the document out of the box and hands it to the girl. What's her name?
Sophia.
Sophia. And says, here, this is yours. And all the other children are surprised because they thought their father owned that property in his, so in trust means he owns it for the benefit of the 2 children, so that when he dies, it belongs to those 2 children. You understand? If he had owned it himself, if it had just been a deed that says the father owns this property, then when he died, then maybe it would be divided among all the children. But since it was in trust for 2 of the children, it immediately belongs to them. And so all the other children, our father, include us in this. And the 2 children, it's George and Sophia, right, who get the property. There are 2 properties. One only goes to 2 of the children. The other one is divided among all the children. And so when the lucky 2 get their deed that says, oh, the property belongs to just us 2 and not the other 2 children, then what does Sophia do? What does she say to her other brother and sister?
We will give you share in the Southgate Street property, but don't you bother us on the Atlantic Avenue house.
Yeah, so she says, everybody understand that? That's correct. So one property goes to only 2 of the children. The other property goes to all 4 children. So Sophia, who's one of the lucky ones, she gets 2 pieces of property. She says to the other children, says, we'll give up our share of this other property, but don't come after us and bother us and try to sue us and say, you know, you should give us part of that property. Just leave me and George alone in the Atlantic Street property, and then we'll give up our part of the other property. Is that what happened?
Then this other property was sold.
Yeah, the other property was sold. And did George and Sophia give up their share of it, like they said? And the answer is no. They claim their share of that property too. And so it ends up in court, and the other children are saying, you promised, again, the contract. What's the contract? It's not just a promise, but the question is your promise enforceable? And they say, you promised if we left you alone about getting the Atlantic Street property, then you would give up your part of our property. But that's not what happened, right? That property was sold, and George and Sophia claimed their share of it. And the other said, that was not your promise. So again, back to the question, like, shouldn't people keep their promises? Should George and Sophia lose this case because they didn't keep their promise?
No, because the court decided that the plaintiffs had no rights
Well,
in
let
the
me
Atlantic.
stop you, Tatiana, and that you're right. That's what the court said, but I'm asking you what you think. Is that right?
I think
Sophia
the
promised,
court,
he said, if you just leave us alone and let us take this property, we'll give up our share of that other property. We'll get this property, y'all will get that property. Everybody's happy. George agreed, right? And then, but when they sold the other property, they claimed their share. They did not keep their promise. So is that, y'all agree with that?
no,
Yeah, it doesn't seem right, does it? Although, but then go back to what did the court say?
the court decided that the plaintiffs had no rights in the Atlantic Avenue property. They didn't attempt to assert any claim, and they promise which was made by a defendant was in question. There are no evidence that this promise was given.
Well, and it's, yeah, it's partly that there was no evidence the promise was given, but really the real issue is the promise is not enforceable. Again, it's like you got promises, but then a contract is a promise that's enforceable. So, and that's what the whole idea of consideration is. Was there any, when Sophia and George said, we'll give up our share of the other property if you just leave us alone about the Atlantic Street property, what did Sophia get for that promise?
She gave the other property.
She gave, yeah, she gave away something, but what did she get for giving it away?
She get Atlantic Avenue property.
But here's the question. Here's what the court said. Sophia already had the Atlantic Street property. The deed gave her the Atlantic Street property. So what did she get for her promise to give up her share of the other property? What did she get for it? And none of y'all can answer because the answer is nothing. She got nothing. You're saying she got the Atlantic Street property, but that's the whole point of the case. She already had the Atlantic Street property. So she didn't give up anything. And the other children, they gave her nothing for that promise. They said, we'll let you have the Atlantic Street property. She already owned the Atlantic Street property. So she got nothing for her promise to give away her share of the other property. Y'all follow? So again, it's this weird idea of consideration. It seems wrong. She and George promised, we'll give up our share if you leave us alone. But then I guess they went back and changed their mind, or maybe they talked to a lawyer and the lawyer said, you didn't get anything for your promise. That's not an enforceable promise. And I know y'all are always looking for something less theoretical and more practical knowledge out of these cases. But let me tell y'all, I don't know how much y'all have been outside of school and done business. And this is a contracts course, and it's all about how to write a contract to do your deals back and forth. But a lot of business happens just like this case, where something happens and people talk, or people are talking on a golf course or something. Not everything, the correct way to do business and make sure you never have a problem, you never have a dispute, is to have a, you know, very precise contract written about everything that you do. And this is exactly what I'm promising to do. And this is what I get in turn for the promise. And this is the consideration. And this is the time frame of it, everything. But that's not the way reality works. For one thing, it would be too expensive if every you walked around with a lawyer beside you every day, you know, everything you agreed to with somebody in business or something else. You know, a lot of deals are made. The people are just talking on the phone. They're talking on the golf course. They opened a box and they were surprised and they said some things. And that's the way a lot of business really happens. And that's why I think why this is kind of a famous case. You know, you could argue that Gloria and George really misspoke, that they made an error when they were talking, because they were all surprised and nobody expected this to happen. They all thought that there were two pieces of property that would be divided among all of them. It was a surprise to find out that one property was only going to two of the children. And so that's the way a lot of business happens. Something goes wrong, and a lot of it is just people talking on the spur of the moment. But it's a lesson of, you know, how that can cause you a big problem in your business. And obviously, I think what happened in this case is that everybody was surprised. Probably the other two children were kind of mad to see that they did not get part of the property. And Sophia's trying to, you know, make them not be so mad. And George goes, you know, George sounds like, you know, he just does whatever his sister says. Probably his big sister's used to bossing him around or something. Anyway, that's the way a lot of business dealings, you know, really work. And then they went back and thought about it later and said, why did we give up our rights in the other property in exchange for the property that we already had? And some lawyer probably said, what, you know, did you get some consideration for that promise? And they're like, no. And so they changed their mind. The other lesson is, you know, you can enforce your legal rights, but you might also make everybody in your family mad, which happens in. You have to think, what's more worth it? You know, should I enforce my legal rights or keep the peace with my brother and sister? Okay, we've got some cases already assigned for y'all to read, so y'all might be reading them for the third time, and we're gonna try this exercise one more time, because I think it is actually, y'all think, Professor, I hate this, but it's actually good for you to learn how to go through and analyze these cases, even if they seem like they're crazy to you, which they usually are. It's like I said in the first class, things don't go to court. If you wrote really good contracts, you never went to court because you foresaw every problem, you resolved everything, you didn't have to go to court. The things that go to court are the train wrecks. And it helps you learn, like, what you need to try to foresee going wrong when you write a contract for something. Like, what that when you write a contract and you're doing a business deal for something, you need to start thinking, like, what could possibly go wrong here, and foresee that and try to address that in advance in the contract that you write. Obviously, Sophia and George, they blurted out something without thinking and then went back and said, wow, that's not really legally correct. So with these cases that y'all have already been assigned to read, which are, you can tell me, there's Newhoff versus somebody, It's a case about replacing the windows. There's De Los Santos versus Great Western Sugar Company. Anyway, I'll send y'all the links to the cases to read for next time. Theoretically, you already read them, although maybe not. But anyway, you'll have had a month to try to get through and read them all. And then take this, and I'll also send you a copy of this diagram of the way to analyze the cases. What's the issue? What are the positions of the parties? What are the key facts? What's the rule of law the court uses? And then what's the holding? How does the rule of law apply to the facts? And y'all do the exercise of trying to fill out that diagram I'll send y'all, we'll try to speed up. We're going slow at first as y'all are learning how to do this. And we'll try to get this, we'll speed this up where y'all can just knock it out and just like, yeah, I can analyze this case really fast. Next class, when the professor asks me, what are the key facts in the case? I already know because I've already figured it out. What are the positions of the party? What did the defendant argue? I already know. They claim that the note was forged. And y'all will get good at doing this. And I hope y'all can get out and enjoy the good weather. I'm going to go try to recover from my horrible, terrible trip. And have a good week. And I will see y'all next Wednesday. Thank y'all.
See you. Thank you
for
for the lecture.
Bye-bye.
Have a nice day.
Yeah, you too. Thanks.